One of the craziest parts of litigation are discovery disputes. When it comes to substantive motions like motions to dismiss, motions for summary judgment, you have briefing, you have oral argument, the court considers your position. When it comes to discovery disputes, a lot of times you just submit a letter, and the other side will submit a letter explaining what the issue is and explaining your respective positions. And depending on the judge, depending on the court, there might be situations in which you don't even submit a letter. Maybe you submit an email. Maybe you just have a phone conference with the clerk or with the judge to explain. And even if you have submitted a letter, a lot of judges, at least in the general part, don't even read these letters in advance. And you basically get on the call and the court will say, okay, tell me what the issue is. And regardless of what you've put in your letter or your briefing, you have to be able to articulate in 30, 45 seconds what the issue is and why you should win. And you can't assume that the judge knows anything about the case or has read anything before. Now, this obviously varies from judge to judge and court to court. In federal court, the judge will have read these papers in advance, and a lot of times the judge just rules on the papers on discovery disputes. In the commercial division, you're more likely to have some type of conference with the judge, but in most cases, the judge or the clerk will have also read these papers in advance and will have considered your position. But in the general part, a lot of times they just have so many cases, they don't read things in advance. Or if they do, they've read a million things in advance, and you have to remind them what your case is about and what your dispute is about and why you should win. And a lot of lawyers get uncomfortable with this. They're good at submitting papers, but they're not good on the spot. They're not good at speaking. It's very important in those situations to be able to give your elevator pitch to the judge on the dispute. It sounds crazy, perhaps it is, but as a lawyer, you have to be able to deal with this. As always, consult counsel early and often.